Hi, this is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2020 Harlan Institute Consource Virtual Supreme Court competition. This year, we are arguing the case of Torres versus Madrid. This will be match number 9. We have petitioner team 7987 with Veda and Skyler, and we have respondent team 8007 with Akshat and Jonathan. Good luck, teams. Petitioners, you may begin whenever you're ready. You'll have 10 minutes.
Thank you, and may it please the court. My name is Veda Swaminathan, and my co-counsel is Skyler Zinker. We represent Petitioner Torres and respectfully submit that this court must reverse and remand the lower court's decisions that wrongfully dismissed this civil action based on a misunderstanding of what constitutes a constitutional seizure of a person, and that the undisputed facts of this case clearly demonstrate that the police attempted to restrain and seize and did in fact seize Ms. Torres when they fired bullets into her body. Under this court's prior ruling in Hodari D versus California, Ms. Torres was seized. In that case, Justice Scalia defined a physical force seizure as occurring when there is an intent to use force, an intent to restrict the movement of a subject, and when physical force is directly applied to the body of a subject, even when ultimately unsuccessful. Hodari D further draws the distinction between what a show of authority seizure is and that it does require submission, and what a physical force seizure is, which does not require submission. The precedent set in Sacramento County v. Lewis indicated that intent is key. This applies to both the intent to use force and the intent to restrict the movement of a subject. Brow versus County of Inyo and the Countess of Rutland case determined that even indirect application of physical force does constitute a seizure. The facts of this case demonstrate that all three of these components were present, and therefore a physical force seizure took place. The intent to use force was demonstrated when the police officers had their guns drawn before Petitioner put her foot on the gas and drove away. There was a clear intent to restrain Torres. Additionally, opening fire on an unarmed woman attempting to flee the scene further demonstrated the police officer's intent to stop Torres. The trajectory analysis presented in the case determined that all shots came from the sides and the rear of the car, so their only course of action could have been to restrain the movement of Torres. When the bullets entered Torres's body, she was seized by the use of physical force on her body.
Okay, counsel, if I could just interrupt you just for a minute. You mentioned Justice Scalia's opinion in California versus Hodari D. What exactly was the holding of that case?
So the case determined that Hodari D was not seized due to the fact that he did not submit to a police's show of authority. So in a show of authority seizure, a submission is required. You need to restrain the liberty of your subject. However, the majority opinion ruled that there does not need to be a physical submission to a physical force seizure. That even when ultimately unsuccessful, subjects.
But what were the actual facts in Hodari? Was that case about a physical seizure of a person?
That
Maybe
case,
this would be a question for your friend Skyler. Did Hodari D actually involve a seizure of a person?
A person and an officer were both involved in Hodari D. The facts of the case include when Hodari was in a park and a police in an unmarked car pulled up, thought they looked suspicious, so the cops shouted at the boys to come over, but the boys ended up running. As Hodari ran, he discarded a package, and after discarding the package, the police caught him and arrested him after physically detaining the boy. The cops found the package and discovered that it was cocaine. Hodari D sued, stating that he was unlawfully seized when the officers began running towards him and consequently had his Fourth Amendment.
But that case didn't. But that case, the seizure was they were running. They didn't actually touch him. Did Justice Scalia's opinion actually turn on whether there was a physical touching of the person?
Scalia draws the distinction here between a show of authority and a physical force seizure. As my co-counsel stated, there was a show of authority that took place when the police began running towards Hodari.
Wasn't Justice Scalia's discussion of the actual seizure dicta, was that actually part of the court's holding?
Hodari D is not dicta under the result that it was established that physical force does not need to have a submission, and Scalia uses the restatement of torts to prove that a submission to the assertion of authority is needed to constitute a show of authority seizure.
Okay, thank you, counsel. You may proceed.
So to continue with why this was a seizure, we are asking the court today to reaffirm the original intent of the Fourth Amendment through this ruling. So the founding era definitions of what a seizure is this term seizure was defined to lay violently or at unawares, wrongfully or by force, and is the act of laying hold on suddenly by the American Dictionary of the English Language in 1828. So success was clearly not a determinant back then of what constitutes a seizure. And according to US v.
But
Jones,
counselor, wouldn't you agree with me that the law has to evolve as society evolves? So it's important for us to understand where we started, of course, and what the founding principles were, but we also have to understand that technology is far different than it was today, that societal norms are different than they are today. Why shouldn't our interpretation of the Fourth Amendment evolve as well?
I'm really glad you brought that up, Your Honor. So if we want to talk about in terms of the modern era, the term seize we can use it in a modern context without success being a determinant. For example, in the sentence, he seized the pencil and then dropped it. The word seizure is used in there. And it does fit appropriately in the context of the sentence. However, at the end of the sentence, you can see that the subject did eventually let go and lose possession of what he had seized in the beginning. So,
right, but a pencil doesn't have free will, right? So the pencil can't resist, the pencil can't flee. So how do you apply that successfully to a situation like the facts that we have here, where you have a woman who floors it to try to get away from police?
So in the facts of this case, Petitioner Torres did not know that she was escaping from police. She believed that she was being carjacked, and that as a lone woman on the streets of an isolated area of New Mexico, she was approached by two ominous figures in the car. And the second thing she sees, aside from these two people outside of her car, is a gun. So the first thing that she thinks of is, oh, I'm being carjacked. And Petitioner Torres did testify that she had been involved in a prior carjacking. So her immediate instinct was to remove herself from what was potentially a dangerous situation. Petitioner Torres had no idea that she was being followed by police. So in their brief, our respondents brought up the fact that the Mendenhall test could be applied here. However, that's not true, because the Mendenhall test asserts that a reasonable person feels that they can flee. Torres did not understand the context of the situation that she was in, and she was fleeing for her life.
So I can just interrupt just for a minute, and maybe it's a question for Skyler. Let me give you a hypothetical, please. What happens if a police officer taps a suspect on the shoulder? Is that a seizure?
That is not a seizure.
Why not?
Well, there was no intent to restrain movement by merely tapping somebody.
Maybe there was. Maybe the hypothetical is the officer wanted to stop them, and when a cop taps you on the shoulder, you get scared, right? And you stop. Why wouldn't that be a seizure under your definition?
Well, it would not be a seizure under our definition as a result of the fact that while I do not know the specific facts of the hypothetical, there was no it's to it's without knowing the facts of the specific hypothetical, it's hard to draw a conclusion as to whether or not there was a show of authority as to it, because it's dependent on what the suspect was doing.
Does your test require, sorry to interrupt, Counselor, does your test require us to look at the officer's intent, or is it an objective test?
It does require to look at the officer's intent to restrain movement.
All right, so how are we supposed to know what the officer intended? I just gave you the facts of a hypothetical where an officer taps someone on the shoulder to stop them, and you said it's hard to know the facts. How will we ever know what's in the officer's mind? I mean, how are we supposed to apply this test on a regular basis?
Well, pertaining to Torres, we understand the intent to restrain movement when officers chose to draw their weapons and shoot at the car, and subsequently bullets entered Torres's body, one which partially paralyzed her left arm. Moreover, the Countess of Rutland case established the first precedent in common law that a seizure can be effectuated even when an officer of the law does not directly touch the subject they intend to arrest. So under this case, the officers did not touch Torres with their hands, but with their weapons.
Okay. Counsel, proceed. Go ahead.
To bring it back to the hypothetical, there are different ways that you can assess the intent of an officer through their actions. So as my co-counsel mentioned, the facts of our case, Torres v. Madrid, clearly demonstrate that the officers intended to restrain the movement and intended to use force on petitioner. So this three-part formula, the intent to use force, the intent to restrict the movement, and the physical application of force on the body of a subject, all constitute a seizure under the common law definition of what a seizure is. So to continue with the Torres v. Madrid ruling, the fact that these three elements were present in the case do determine that a physical force seizure did occur, and that Torres was seized the minute the bullets entered her body. It was a momentary seizure. As soon as the bullets entered her body, she was seized in that moment. And through that, we can determine further through the lower courts, once this case is reversed and remanded, as the petitioners hope, about whether it was reasonable or not. So first, we must determine whether or not a seizure occurred. And based on the facts of the case that the petitioner's counsel has laid out, and based on the quintessential seizure of a person under Fourth Amendment jurisprudence, as Justice Scalia wrote in the Hodari D versus California ruling, because there was no submission to a show of authority, because there was no show of authority seizure, the petitioner was seized under a physical force definition. Thank you.
Okay, thank you. Okay, you're right on time. Thank you so much, Counselor. All right, we have 15 minutes for the respondents, whenever you're ready.
Mr. Chief Justice, and may it please the court. The whole of American constitutional jurisprudence centers on the principle that justice must be dealt out equitably and reasonably to all parties involved in a dispute. With respect to Fourth Amendment claims, the constitutional rights of individuals must be delicately balanced with the responsibilities of law enforcement to ensure that the laws are faithfully enforced. On July 15, 2004, police officers Janice Madrid and Richard Williamson were performing their legitimate duties as officers by conducting a stakeout. Upon noticing Roxanne Torres parked nearby, they approached her vehicle and verbally instructed her to either leave the vehicle or allow them to enter. Rather than comply with the officer's request, Torres began to drive her car, a 4,000-pound vehicle. At this point, the two officers were confronted with both non-compliance with their instructions, as well as a sudden movement of Torres's vehicle while they were unprotected by a vehicle of their own. As any reasonable person would, the officers made the bona fide assumption that this suddenly moving vehicle posed a threat to their lives, and as per the objective reasonableness standards set forth by this court in Graham v. Connor, the officers' actions thus did not constitute excessive force, so long as their actions would have been made in good faith by an objectively reasonable official. As any reasonable official would perceive a car moving at that fast speed as a threat to their lives, their actions were made in good faith and were completely reasonable. Torres's actions, on the other hand, created an immediate exigency for the officers to respond in the reasonable manner that they did. Her vehicle threatened their lives. She successfully evaded the officers and proceeded to steal another vehicle and drive 75 more miles. In 2015, Torres would eventually plead no contest to evading and assaulting police officers, as well as unlawfully taking the motor vehicle that she stole after she fled. Her nolo contendere plea perfectly exposes the reality that Torres's actions were threatening to Madrid and Williamson, justifying their subsequent response.
Counsel, if I could jump in for a minute. Isn't this case controlled by Hodari D?
This case is similar to Hodari D, but ultimately the facts are different enough, and any standard used in a Hodari D that could be applied to this case is extremely dicta. Petitioners brought up the idea.
Why is Hodari D dicta? Why Justice Scalia's opinion dicta?
Facts in Hodari D are quite simple, are quite different from the ones that occur in this case. In Hodari D,
I think he's trying to answer. Jonathan, go ahead.
Yeah, a holding consists of propositions of three things. One of those are actually decided, two are based upon the facts of the case, and three that lead to this judgment. Hodari D fails to meet the second and third requirement because the facts of the case don't suggest anything about unsuccessful applied application of force. Since the officer successfully tackled with Hodari D, and before that he threw away his package of drugs. And more importantly, the consideration of the successful application of force was not relevant to the case. And this was clarified later within Brooks v. Gonzal, which redefined the application of force, finding a seizure requires restraint of one's freedom of movement and includes apprehension or capture by deadly force.
So, counsel, let me ask you another question, please. Let's say Justice Scalia's opinion was dicta. Was he wrong? Why can't we just find him persuasive?
we could consider Justice Scalia's opinion to be persuasive, but ultimately the facts are different enough that to apply those different facts to this case would constitute an evasion of justice.
Well, then,
Justice requires us.
How did Justice Scalia define a seizure?
He defined a seizure as any attempt at force to restrain a person or an object. But in that case, it was based around evidence.
I'm sorry, does that force have to be successful?
It does not always have to be successful, but in this case, the actions did not make any attempt at restraining the object, and Torres was able to flee completely after she was shot by the officers.
Well, let me ask you this then, Counselor. How much success is required under your test? Is it enough?
Our test, which is based on definitions within both Florida v. Bostic and Bauer v. County of Inyo, we define as a successful seizure by physical force or show of authority that terminates or restrains one's freedom of movement through means intentionally applied. This differs heavily from Justice Scalia's definition, which is only under physical force through means intentionally applied and does not require the termination of one's freedom of movement. But as stated before, his opinion within Hodari v. Is dicta.
So at what point is someone's movement sufficiently restricted that they've been seized? So say, for example, that you have a suspect who did flee and shots were not fired. And this person is just a terrible driver, loses track of the car and flies into a barricade, but the police catch up with her. Has that person been seized within the meaning of your definition?
That person has not been seized because we would like to define it as both termination of one's freedom of movement and in addition to that, submission to that seizure. That's stated within County of Sacramento v. Lewis, where it says that there's no seizure without actual submission. So though this person in this hypothetical crashed, there's no submission to the force applied by officers.
So doesn't your definition then reward a fleeing felon or reward someone who's got superhuman strength or is just simply stronger than the officers and can break away and run farther, or who isn't necessarily impacted by a bullet? Say that, for example, my co-justice here has superhuman strength and a bullet doesn't take him down, but it takes me down immediately. So how do you justify that discrepancy?
We justify the discrepancy between the two because searches under the Fourth Amendment must have a common application. And if we were to say the opposite, that any application of force that was physical with intent to subdue the person in this case was a seizure, there'd be questions along the lines of what would be an effective seizure. So any person really running and suppose one person was like you said, with superhuman strength, continued to run, but officers somehow applied physical force, that person was seized, it would come up with a lot of different situations and hypotheticals that would make application of the law extremely difficult. So we'd rather have these, hypotheticals in cases that people escape, rather than have application of the law that simply cannot be possible.
Well, Counselor, let's just this for Akshat. Let's just be realistic here, right? The police shot this woman 13 times, right? How is that not a seizure, right? The fact they didn't kill her is only by the grace of God. A bullet moves a couple inches to the left and hits her spine and she's dead. How is this not a seizure for the Fourth Amendment? How do we not allow recovery here?
The issue is that the alternative would be that any fleeing suspect has a Fourth Amendment right of action against police officers. If situations like this were to be considered.
But not everyone shot 13 times. These are pretty egregious circumstances. You only need 2 bullets, 1 bullet to kill a person. You don't need 13 bullets.
But in this case, the officers believed that their lives were at risk. This was a massive vehicle that suddenly moved. Petitioner Torres did not respond to any of the officers' requests to open the door, to get out, to stop the car. She kept on moving. She would continue to move for 75 miles. The officers, they believed that their lives were in danger initially when the car started moving. So they unloaded those shots because they believed that it would be the only way to save themselves, like any reasonable officer would have done.
So, I'm sorry. So you think this was a reasonable seizure? Do we have to decide whether the seizure is reasonable in this case?
In this case, it's not reasonable, but assuming arguendo that this was considered a seizure, it would still be.
I'm sorry, it's not a reasonable seizure? I didn't know what you just
It's not a seizure. Even if it were to be considered a seizure, their actions were still wholly reasonable.
All right. Well, let me give you a hypothetical for Jonathan, if I may. Let's say instead of shooting her, they tried to do something else, right? Let's say that they knew she was going down the highway at 75 miles per hour, and then they called their friends who were further down the road to put a police barrier, like a cement roadblock, in the middle of the highway. They just put a roadblock in the middle of the highway. It's late at night, it's dark, she doesn't see it. She can't swerve out of the way. and she slams into the barrier and wrecks her car. Is that a seizure?
Yes. Under, I believe, Broward versus the Supreme Court decided within a 9-0 majority that a police roadblock could constitute a legal seizure under the Fourth Amendment because the police intentionally applied this physical force to these persons or object by placing the roadblock there.
Well, how is that different throwing a bullet at her, or shooting a bullet at her?
Because with a roadblock, that immediately stops and prevents the person from moving. Going back to our definition of deprivation of liberty and essentially freedom of movement. In this case, Petitioner Torres, although struck by 2 bullets, was able to continue moving almost 75 miles away from the scene. And that difference is what we're relying on within this case.
So let's take Justice Blackmun's example a step further then. She slams into the barricade, but decides that she still has enough wits about her to get out of the car and start fleeing on foot. Has she been seized?
In that case, I would argue that Petitioner had not been seized since, again, going back to that definition of deprivation of liberty has not occurred despite intentional application of physical force.
So her liberty hadn't been constrained by this barricade that forced her to that she was forced to slam into solely because she was able to get out of the car and start walking.
Correct. By demonstrating freedom of movement, the petitioner in this case, or within the hypothetical, demonstrated that he or she was able to continue, and therefore it had not occurred, and an effective seizure had not occurred.
Well, let me ask you a policy question. Maybe Akshat, you could tell me what you think of this. I thought that the Fourth Amendment and our jurisprudence indicates that this is supposed to protect people against state action, against what the officers in this situation would do, not to test what a defendant can take or how good their car is and their airbags are and whether they can get out on foot. So how does this fit into what the original purpose of the Fourth Amendment was?
Thank you for the question. So the Fourth Amendment was designed to protect people from undue government action. But at the same time, the court must balance the rights of individuals under the Constitution with the requirement that police officers do their duty and execute the laws. If any defendant who were fleeing were allowed to flee and police officers were not allowed to shoot at them or not allowed to try to attempt to stop them in any way, then, and they would have a Fourth Amendment cause of action, then any person who thinks that they might have committed a crime or any suspect would be able to flee and police officers would have no cause of action against them. If justice is to be preserved and police officers are to prevent crimes and to ensure that justice is kept, then they need to have the ability to attempt to restrain people just like the petitioner without having Fourth Amendment causes of actions.
Well, let me ask you a question, Counselor. What do we do then with these sorts of really egregious cases, right, where a person is shot 13 times by the police, has paralysis, and can't have any recovery? Is there nothing for Torres here? Is there nothing for us to do for her?
It's possible that there were other actions committed by police officers. It could possibly construe to be assault, but all of this would also fall under the qualified immunity of the police officers. So the only question here is not other crimes or other actions that might have been committed, but only whether this was a seizure or not. So it is ultimately not a seizure.
Counselor, as far as common law cases, what's the best case you have in support of your position from your best English case?
Ultimately, this closely follows the ideas that happened in Graham v. Connor, where the question is merely, did the police officers respond reasonably to actions taken by the petitioner? In this case, their actions were reasonable. They did not commit seizure. They were merely doing their best to prevent the petitioner from committing any further crimes or from escaping.
Really, recent case from the 1980s. I'm asking like from England, like old cases. What's like the best case you have?
At this point, it is close to impossible to compare this to English common law cases, merely because at the time there were no automobiles, there were no vehicles. So what needs to be done?
There were weapons. People had weapons. Well, why is it so hard to compare?
So if one were to compare a weapon, for example, using a sword to attempt to stab someone, if a soldier, if a peace officer was chasing after a suspect, attempted to use their sword, touched the suspect, but the suspect continued to move, that doesn't count as seizure because the suspect still had their wits about them. They still had freedom and they ultimately weren't seized by that officer. The same idea applies here, where although the officers attempted to shoot Torres still had freedom of movement. She was still able to escape, commit more crimes. So it does not fall under the definition of a seizure, common law or otherwise.
Okay, you proceed, Counselor.
So going back to this definition of seizure as outlined within previous cases, such as Florida, Bostic, and Broward v. County of Inyo, this is also supported by the original public meaning of the word seizure. Now, of course, definitions evolve over time. However, it's important to note that the word seizure meant a taking of possession, and that's supported by American Heritage Dictionary.
I'm sorry to interrupt. What evidence do you have of the original public meaning of seizure? What evidence do you cite?
We would say evidence from public documents from the time, such as, again, these dictionaries that define seizure as most directly to the act of taking.
Which dictionary are you looking at?
The American Heritage Dictionary and Black's Law Dictionary. They define seizure as the act or an instance of taking possession of a person
Are these
or
modern
property.
or dictionaries from the 1700s?
These are dictionaries from as far back as 1588, as well as more modern dictionary from 1891. And so they closely mirror the sentiment at the time that the Bill of Rights was written, what the definition of seizure was to the authors of the Bill of Rights at the time.
Okay, thank you. We have about 40 seconds left. You can proceed. You can wrap up.
Great. So the standard set by Florida v. Bostic and Brenly v. California maintains that an effective seizure under the Fourth Amendment occurs when termination of one's liberty and submission to that termination occurs. Similar cases, including Broward versus County of Inyo, also hold that a Fourth Amendment seizure does not occur whether there's a governmentally desired termination of an individual's freedom of movement, but only occurs when there's a governmental termination of that freedom of movement. That is to say, desire alone is not enough to implicate petitioner's Fourth Amendment rights. And given that petitioner was able to freely drive past officers, steal another car, and drive almost 75 miles, there is no termination of liberty or submission to that termination.
For that reason, this court should uphold and affirm the decision of the United States Court of Appeals for the 10th Circuit. Thank you, Justices.
Okay, thank you so much. All right, we now have 5 minutes for rebuttal time. The petitioners, please come back on the screen. There you are. Okay, 5 minutes, begin whenever you're ready.
Thank you, and may it please the court. Now, the question at hand today is not whether reasonability occurred, but whether or not a seizure took place. Thus, the respondents persistently bringing up Graham versus Connor is inapplicable, as that case is a matter of excessive force, and it must be constituted whether or not a seizure has occurred before the matter of excessive force is argued. The court deemed in Graham versus Connor that an objective reasonableness standard should apply to a civilian's claim that law enforcement officials used excessive force in the course of making an arrest. Now, what is being argued today before the court is whether an arrest and seizure occurred. Now, please put yourself in the shoes of Torres, a young woman in her car alone, as the day begins, as the sun begins to rise, when officers are not completely visible. She is not in the mindset that officers will approach her vehicle, and she's all alone as she had just dropped her friend off. All of a sudden,
all right, counsel, let me ask you a question. I'm familiar with the facts of this case, but if we adopt your rule, wouldn't this lead wouldn't this make it very hard for police to do their job if police are always worried about getting sued? In other words, doesn't your rule make it very hard for the police to try to keep us safe?
I would argue that our rule does not make it difficult for the police to keep us safe as a result of the fact that what took place in Torres versus Madrid were extremely egregious manners because the police shot Torres 13 times and 2 of those bullets entered her body. Had the guns not been drawn and the bullets missed her body, then we would not be in this position and officers would not have a difficult time of keeping us safe, because as the respondent stated that officers acted in a reasonableness manner, but 13 bullets is anything but reasonable, and that is clearly a seizure as there was an intent to restrain movement.
So, again, let me ask you the tapping on the shoulder hypothetical, right? In other words, if we adopt your rule and if a police officer decides to tap someone on the shoulder, why is that not a seizure?
So in relation to relating the hypothetical to this situation, in the hypothetical, if the police officers had acted how the police officers did not act in the Torres v. Madrid case, for example, if the officer had identified themselves as a police officer and if they had followed all of their basic training, the officer would not have, there would be no constitutive of a seizure because the subject in the hypothetical would submit to the show of authority of being stopped by a police officer. If a police officer said, stop in the name of the law, I'm a police officer, and vocally identify themselves, which the officers in Torres v. Madrid did not do, it would not be a seizure because they submitted to the show of authority.
But police don't always have that much time to make an announcement. What if they just have a split-second decision and they need to maybe grab someone's shoulder and just sort of put their hand on their shoulder, and they don't have time to announce themselves, and then the person runs away.
So if there was the intent to restrain movement, the intent to use force, and a physical application of force onto the body of a subject, then it would constitute a seizure. However, the argument that this would limit the police officer's ability to do their jobs leaves out the fact that police officers are supposed to be trained to follow their law, to follow their training. And in order to do that, there are certain steps that they need to follow. And without those steps, you do leave open the possibility of walking into an excessive force claim or walking into a reasonability.
Counselor, if I could ask, your friends on the other side broke qualified immunity. Do you think qualified immunity plays any role in our decision today?
Qualified immunity should not play too much of a role in the decision today, due to the fact that we are talking about a seizure, not about reasonability. In order to determine whether qualified immunity plays a role, or to determine whether excessive force happened, or determine the reasonability, we first must make clear that a seizure did occur today. So it is the court's job today to rule, in fact, or we urge the court to rule that a seizure occurred, so that the lower courts can then go on to rule whether qualified immunity plays a role, whether excessive force plays a role, and whether it was reasonable or not. So based on the facts that we've presented for the petitioner's counsel, and based on the fact that, even under the own test of the respondents, Petitioner Torres was seized through the fact that her movement was restricted to a degree. She was partially paralyzed, so that freedom of movement was restricted to a degree. She was seized, and in order to determine whether excessive force was used, we have to reverse and remand to the lower courts.
Excellent. Okay, right on time. Thank you so much. If the other team can please come back on the screen, and Mr. Holy can come as well. That was wonderful. I think you'll need to know the reason why we're so tough on you is because we think so highly of you. And the reason why we ask such difficult questions, we think you can handle it, and you all handled it spectacular. This competition truly gets better every single year I do it. Mr. Hull has been doing this now for a couple of years now, and I think he can attest that it gets harder and harder. Every year you bring your A games. And I'm very proud of each and every one of you. You all have bright futures ahead of you. I could not have done this when I was 16 or 17 years old. That's for sure. And she'll be very proud. Just a few specifics. I really appreciate that you're bringing in old cases, and the Rutledge case, and talking about contemporary definitions. I tried to give you very hard hypotheticals to throw you off your game, and you stuck to your line. You did not change your answer no matter how hard I pushed. Ask you policy questions that making it harder for police to recover, making it hard for police to do their jobs, and you didn't budge. So this was really strong. I think I can tell you put a lot of prep into this, and you should all be very, very proud of yourselves. Sam?
I agree. This is not an easy thing to do. One of the things that I did in law school was a competition that's very similar to this, where you brief to a mock Supreme Court, and then you go and you argue in competition. I think the only difference is that which side you argue is decided by a coin flip. So you get a little better time to prepare this way. But your rapport with the court, your knowledge of the case, your passion, I think, is really evident. I think sometimes people get a little bit too caught up in being hyper professional, hyper technical. You forget that there are real people involved. And I think that's what we were trying to get to, and trying to really press you on, was this really impacts someone's daily life. Veda, you mentioned, we can train police officers on rules. You bring up the fact that this is a real human being who had to deal with police shooting at her. So it's good to keep that human element to it, even though we're talking about a very big issue.
Excellent. I always pause and say, if you have questions for us, things on your mind, things that you want to ask us. Go ahead.
I just wanted to say thank you for this opportunity. Like, this is such a unique competition, and I do want to end up going into law in the future. So this was really awesome to get like a first taste of what I hope to do for the rest of my life. So. Well,
that's great. Are anyone else considering perhaps law?
I am as well.
You too, Akshat? All four of you. Do you have attorneys in your families, if I can ask?
Wow.
That's even better. That's even better. Most people don't have that. Well,
that may be why they're considering law.
Oh, that's funny. You're very funny. Well, let me. I gave you an offer. I emailed Aaron earlier. I teach. I'm a law professor. That's my full-time job. And if you want to visit my common law class this week, you're welcome to come on Zoom. It's Mondays and Wednesdays. 2:30 Eastern. And I sent your coaches the information. So you're welcome to come by and stop my class and just watch. I may call on you. You can also ask questions if you want. That's fair game. But you're welcome to come by anytime.
Thank you.
Thank you. That's amazing.
My pleasure. What else do you want to ask? Anything on your minds or anything you want to inquire about?
Is there a reason you specifically chose this case for this competition?
It's a good question. So every year, and Aaron will attest to this, we try to pick a current case that is well balanced and gives students an opportunity to argue on a fun issue. In this case, I guess it's not so fun because women got shot, but the issues itself are I think very, very well balanced. There's precedent, there's text, there's history, there's policy, and it really lets you run with it. What I didn't anticipate was the court would decide the case so early. Usually the case is decided by like June. So this was a little bit early, but it was a fascinating case, split 5-4 right down the middle. So this was not an easy case at all. And even the justices don't agree on the right answer. So I think you all did a really sharp job. We've done in the past cases on free speech, on religion. We've done a wide range of cases, but this was a good criminal case we liked.
One question, and maybe this is a bit premature, and if you want to defer, since there are subsequent rounds, but you did have a split in the court among Federalist Society members and originalists. Are you at liberty to comment at all on your take on that?
I'm with the dissent. That's easy. I'm with the dissent. I think the chief's opinion was a little too fast and loose. I think he put a lot too much weight on the debt collection cases, which I don't know how relevant they are. If you all read the case, or at least you've seen it, yeah. I mean, the Chief Justice wrote the majority, and the dissent was by Justice Gorsuch. I think Gorsuch had the better argument. I don't think it was perfect, but I think Gorsuch had the better argument. But it's not my area. But I'm usually not with the chief in most cases. Sam, do you have any thoughts on the case?
I would say that I'm on the opposite side. I was with the majority. I thought that it was well reasoned, and I think that there's a better argument there for what the Fourth Amendment is supposed to accomplish. But I agree that it's Fourth Amendment decisions and case law are it's a very difficult area that has it's a place where you see the pendulum swing all the way one way, and then you start to see it sort of come back a little bit with time, especially when you have this length of time interpreting an issue. So it is a tough area of law, I'll say that. And because the facts are always so different, you have to look at things from a really difficult angle most of the time.
Good. What other questions do you guys have?
What do you think is the most politicized amendment?
Oh God.
Oh wow.
What a smart question. I mean, the Due Process Clause, the 14th Amendment, has led to some wide-ranging rulings, everything from abortion to a liberty of contract, assisted suicide, eugenics. I mean, almost everything you can think of has been sort of lumped into the Fourth Amendment. But that's a really good question. The Second Amendment is pretty politicized also, which is what I'm teaching in classes this upcoming week. First Amendment's led to some crazy results. I mean, there's so many provisions of the Constitution. I'll go old school and say the Contracts Clause. It used to be very controversial in the 1800s about whether the states can violate contracts. That's a huge area of constitutional law in the 1800s. Not what you were expecting me to say, I bet, huh? But it was a huge issue.
Yeah,
really thoughtful question, I think.
Right. I think from my perspective, it's probably either the Second Amendment. It seems to be politicized the most, but I think the First Amendment is more misunderstood commonly, and what it's meant to accomplish and what it does. And this idea, I think, that we've lost about freedom of speech does not mean freedom from consequence. So it's an interesting thing to, once you get into, there's a reason why their whole course is devoted to First Amendment law.
Building on Veda's question real quick, is the Due Process Clause less politicized if the Privileges and Immunities Clause was not eviscerated by Slaughterhouse?
Now you're talking about language. Yeah, I mean, look, this is a classic question about what the correct interpretation of the 14th Amendment. And if you don't already have a copy of my book, 100 Cases, you should get a copy. Substantive due process sort of just runner on the rails. I think one of you mentioned Sacramento v. Lewis, and that's an important substantive due process case, that even if the Fourth Amendment perhaps doesn't provide a remedy for the plaintiff in this case, this might be conduct that shocks the conscience. They shot her 13 times in her driveway. So even if she loses under the Fourth Amendment, she has a 14th Amendment claim. What else is on your mind?
I will pass that information on about your classes, professor, but thank you again for doing the competition. I want to echo all my team members in providing this opportunity, because I know it's pro bono work, as they say, and fantastic pro bono work. So
I love it.
With a real tangible outcome. So thank you.
Great. Thank you. We'll be announcing the scores tomorrow, and we'll be letting people know what happens next, but you should be very proud of yourselves. All right.
Very nice job.
Thanks so much. If the students can sign off and coach will sign off, and I'll just confer with Sam for a bit, and then I think I have a lunch break. Then we'll be back in the line about an hour after that. So thank you so much.
Thank you so much for holding this.
My pleasure. Take care, guys.
Thank you.
Bye.